We shall live in peace.
Now they indicated that what is what moved out. And we said, okay, if we are here to entertain the application for mandatory bail, we are ready to proceed. And we were waiting for the pronouncement of court on that matter, that proceed with your application for mandatory bail, then we make it. Now, they appear to have responded to the application before we made it. May we be permitted now to also, I don't know, if we could be given it, because they are raising issues of regulations, we need to address what on issues of regulations.
Defense has raised several issues, which court has to address. Can I make a ruling on this as it is?
And if court is going to make a decision on the same, it would only be fair that we raise some issues in regard to that particular matter, even if it's only that issue alone. Just on the case. Not yet.
Can I rule on what is here?
Most of
Bearing in mind what you submitted.
Most of that.
And then the submissions on the issues raised. The issues raised majorly are in regard to legal representation as provided for under the Constitution. The defense has raised an issue that the two accused persons are represented by Counsel Martha Karua, who is currently in Nairobi, and ought to be here to represent her clients. This court is mindful of the right to legal representation as provided for under the Constitution of Uganda. The accused persons are before court and are ably represented by lawyers, although they said that Counsel Martha Karua is a lead counsel. Whereas this court appreciates her role as lead counsel, I believe that the team of lawyers in court present can ably represent the accused persons for today's hearing. This court thus believes that the accused's right to legal representation is guaranteed. this court thus finds no basis to refer the matter to High Court under the Human Rights Enforcement Act. Counsel Lukwago has submitted that they are in court today to make an application for release of the accused persons, and as such, the submissions made by the prosecution are done prematurely. The accused having appeared in court on a production warrant, the prosecution should proceed to make its application or proceed with the production warrant, the reason why it was issued, and thereafter the defense may make the prayers they intend to make in regard to the liberties of the accused persons. This way.
Your Worship, the lawyers don't have instructions from us to proceed in the absence of their leader. I don't know where that leaves us. Because we appointed the Honorable Martha Karoa come from that far. Very cognizant of the competence, the availability of our current team that we have. But she has a special role for me that we have had to incur that great cost to get her here each time to follow up this case. And as the lawyers have indeed ably pointed out, she was here and we are ready to proceed. Only that it was not very possible. We are now informed, I was informed at 7 p.m. last night that there is a here that the protection warrant has been received. And indeed so have our lawyers, some of whom are not. So, Your Worship, our lawyers definitely don't have instructions from us to proceed in the absence of our lead counsel.
Your Worship, as our client has submitted here, we act on instructions. As our former client. Our client, as far as the matter is concerned. But today, the matter where we have instructions is supposed to come up on 29th of December. So we appeared here on Wednesday this week, and that matter was adjourned 29th. As for the proceedings of today, where we do not even have a copy of the letter, which is moving to court to proceed, where we have no idea as to the substance of what is going to be released, we are also going to be watching.
From the time when this court convened, it is on record the accused person A1, A2, and A3 were in court. It is also on record that when they were in court, Lord Mayor, Senior Lord Mayor, Lukwago, introduced himself and his entire group as lawyers representing the accused person. And the accused person was listening. I'm submitting. If there was anything to do with not instructing them to do anything in the absence of Martha, then he should have raised it at that time. How did they come to represent him in this court today without instructions? This is what we've been talking about: arm twisting prosecution, delaying, frustration. And then they start lamenting 6 months. Prosecution is making a headway into investigation. It is expediting the process. Defense is holding it back. And then they come and submit how the rights of the accused person have been infringed upon. I think this is a duty of both prosecution and defense to ensure that we have an expeditious process in this matter. Cite other rights, and then you leave the right to speedy and expeditious trial, which we are talking about. In any case, there has not been any substantive reason as to why the absence of Martha can stall this matter. This is a prosecution case. Looks like defense is taking it over. Now court has to dance the tune of the defense. We are being held back. Court has already made a ruling on that. If A1 retired Colonel KIZZA BESIGYE knew that he had that in mind, he should have raised it even before this court made that ruling. We are submitting that that is an abuse of the process. It amounts to an abuse of the court process, which is detrimental to this matter. Why this matter is in court? First of all, this is at a preliminary stage.
Let me just stop right there. Make the ruling. So you made the submission after my ruling. On the fact one.
I hardly know the gymnastics and procedures. There were many things that were being talked about. I do not know whether or when I should step in or not. I thought I had to, when I heard you say that the matter can continue without her. I did not know that it had come to that. And I have to alert you about our decision. So if prosecution wants to continue without us being represented, there's nothing to be done.
Your Worship, it's not factually correct that indeed this matter has been canvassed in the with all due respect to Your Worship. Why, Your Worship? We clearly indicated to court that we had instructions to proceed with an application for mandatory bail. We have no instructions to proceed with a matter which is not known to us. We can only get instructions after we have known what the matter is about. Up to now, the state is holding on to the letter that was written to court. We don't know what is contained in the letter. We have no idea as to why the state moved the court. The last time we appeared here on Wednesday, Your Worship, the matter was adjourned to Thursday, 29. So why we are here, we don't know. And that's the reason we raised and said, Your Worship, can we be permitted to proceed with the matter where we have instructions? That is the application for mandatory bail. If court is not ready to entertain that application for mandatory bail, we have no instructions to proceed with a matter which is going to be raised by the state for even sake which is not known to us. And on that note, Your Worship, with all due respect, if you could permit us to withdraw from the bar and to proceed with a client. You proceed with an accused person in our businesses. Yes.
Before you withdraw, I noted in my ruling that Council Martha, as lead counsel, even if she's not here, if the other lawyers are here, they can ably represent the one. And I noted that it is prudent that we hear why we are here, why we hear from the prosecution in regard to the production warrant. I think it is only prudent that you hear what he has to do first before you withdraw.
Mr. Brad, Your Worship, we do appreciate all that, Your Worship. But, Your Worship, we have made reference to the provisions of Section 76 of the MCA that once an accused person has brought 6 months on remand, no any other business shall be entertained by the court apart from the application for mandatory bail. First, that is Section 76, Your Worship.
Let me just to cut you short. And I'm simply stating that before you go into all that, can court hear what the prosecution has to say today? Let the prosecution address court.
Your Worship,
Counsel, please, let prosecution address court and then you hear from court.
with due respect, Your Worship, of permit us to read with evidential
He says, well, but let the prosecution address
Order, please. Order. Give us way. Give us way.
The case we face here